Insurance intermediaries have various obligations under the Insurance Supervision Act and the Insurance Supervision Ordinance. This video informs you about these obligations and shows you, as the policyholder, your rights and options to protect yourself against any misconduct or abuse. All insurance intermediaries must provide you with various information during the consultation. For example, about their identity and how you can find out about their training and further education. They must also tell you whether the intermediation is taking place on a tied or untied basis. If you as a client can choose between different insurance companies for a particular insurance solution, the intermediation is untied. In contrast, tied intermediaries generally only represent one insurance company, and there is no choice. Tied intermediaries must not give the impression that they are independent. In the case of untied intermediation, the intermediary company and the person providing the advice must be entered in FINMA's public register. Entry in the register means that the minimum legal requirements are met on an ongoing basis. It does not provide, however, conclusive information on the quality of the advisory and intermediation activities during the sales dialogue. Make sure that the insurance intermediary at the consultation is who they say they are. Untied intermediaries must inform you clearly and transparently about the compensation they will receive from the insurance company for brokering the insurance offered before the contract is concluded. The amount of compensation may have an influence on the insurance products offered by the intermediary. As the policyholder, you are entitled to know the exact amounts. Be critical when making contact during the consultation and before taking out an insurance policy, and make use of your right to information. Before concluding a long-term contract, such as a life insurance policy with a savings component, for example in Pillar 3A or 3B, have the important questions explained to you in detail and answered in writing. This is the only way you will be able to prove any errors or omissions in the advice at a later date. For unit-linked life insurance policies, i.e. products with invested capital, pay attention to the sample calculations and the scenarios for the possible development of returns. Be aware that the unfavorable scenario may well occur, and you could lose a lot of money as a result. All the more so if you have to withdraw from the contract prematurely. If you have any doubts about the product, we recommend that you obtain a second opinion. Please note that you have a right of withdrawal of 14 days from the date of application or acceptance of the contract. The notice of withdrawal must be sent to the insurance company in writing or handed over to the post office within this period. If you believe your rights have been violated or suspect a shortcoming, you can report this to FINMA. Submit your complaint via the FINMA website. Further information can be found on the FINMA website and in the corresponding legislation.